if you have CCTVs
Yes.
in your exam halls, that means that anyone that has been involved in
Yes.
malpractice is
We can
caught
play
on
back
camera.
and- yeah, but there's no dispute in that, sir.
Okay, so and then as well, if someone is caught with contraband materials for exams,
So, Chairman, you know the name,
pictures.
Chairman. I didn't know.
Huh?
I didn't know that you know the name is contraband. That's what we call it. Mr. Chairman.
Pictures taken of the exhibit
Yes.
and documented.
Okay, Chairman, sir, can I approach the chair and give you something now so that you can see? Just like this, sir. I'll bring it to you, sir. So this one, is there any dispute here? There's no dispute, sir. There's no dispute. Please show our.
The prof has shown us evidence of malpractice, very concrete evidence, and members have seen it, and we understand what you people are going through right now, because it seems you have some people that are proper accused that are trying to be lawyers.
Yes. In fact, I didn't know that this matter is coming. I would have brought the chief so that you see somebody is coming with a whole examination booklet into examination of the chief. So what I want to say clearly, law school, like every organized system, has its own calendar. And whatever we do in law school is based on this calendar. At the beginning of every session, we advertise for admissions. We have timing for when admissions will end, our lectures, externship program, when students come out to do more trials, examination, timetable for examination, when the result is to be processed, and when result is to be out. In all these things, each body has its own role. For example, when it comes to examination, when examinations are marked, it goes to Board of Examiners. Board of Examiners simply means all deputy directors and directors of the law school are members of this body. What they do is to look at these results with the hope that this result meets our own expectation that it will pass to the Board of Studies. The Board of Studies is a committee of the council. They also look at these results and pass to council. What council does is to either ratify or make certain decisions on these results. And in our system, once council approves results, that day, that result is out on our portal. That's how this system works. So the issue of withholding result does not even arise. This result comes out the day council approves. So when we saw that people were writing to National Assembly to say that they should intervene to ask us to release result that we withheld, no reason for withholding results. Any result withheld in law school has to do, for example, with examination malpractice. These are also very few cases. Is there even in the universities? This matter goes to council. Council takes its own decision. So we don't withhold any results. The second issue that's closely connected to this is they asked the House of Reps to a committee to ask us to release results. I mean, call to bar. The call to bar is not an activity of council regulation or Nigerian Law School. It is the activity of body of benchers by regulation. And body of benchers also, like I've said, every system has its own calendar. The body of benchers has decided long ago, call to bar will be in July and November. And that's the reason why these students who have passed by examination are going to be called to bar specifically on the 10th, on the 8th to 10th of July this year. And another group that the backlog set also are going to be called to bar from 18 to 20th of November. That is how this process works. That these students, they are the ones who went to law school who cannot identify functions of bodies in legal profession. Yes, I'm sure they are among those who didn't pass law school. Yes, that's what I've said. Every lawyer that is worth his salt, no matter how poor a lawyer should be able to identify functions of these bodies. Because that's what you do in professional ethics. And I'm sure those who are coming to say we refuse to call them are those who have failed by exams. That's what I've said. I can attest to the worthiness of my students. That one I can tell you anytime. But those who are those who didn't pass by exams. That's what I've said. This process is a very simple one. Anybody who wants to run a law program, the first thing he does is to approach the National Universities Commission to seek for approval. And I'm sure it goes up to the Federal Executive Council. When it is approved, they do a resource verification and they are allowed to start a law program. But they are told to liaise with Council of Legal Education. When they write to Council of Legal Education, we ask them to attach the NUC approval to say that they have been given approval to start a law program. Then we write them to say, okay, fine. We receive your letter, but these are our guidelines. Criteria for doing the program. You must have classes, you must have teachers, you must have a moot court, law clinic, you must have our faculty must be, we don't share facilities with anybody.
You must have a very good library.
Library, both e and hard copy, and we don't share facilities with anybody. We also tell them that the dean must have a car, they must have a utility vehicle labeled with the name of the university and faculty. We've also asked them that each of these classrooms that you want to use for teaching must be air conditioned. There must be public address system. There must be interactive boards for teaching and learning. Teachers must have good offices conducive for learning. They must have tables, chairs, visitors chairs. They must have air conditioning system. They must have television with satellite, with a fridge. So this is our own basic requirements. So anytime we go there, we tell them these are the basic requirements. So universities must satisfy this to start a law program. When they do this, now they write to us to say we are ready for your own resource verification.